Okay, good day, everyone. We are back and welcome. We'll continue our discussion on the course of the law on partnerships and corporations. And this time around, we'll discuss the obligations of the partners. Obligation of the partners towards another partner or to his partners, to the partnership, and of course to third persons like the creditors, suppliers, the clients, and customers. Okay, we begin a discussion with the obligations of the partners to one another or to his fellow partners. And there are five, and these are enumerated in Article 1786, 1788, and also 1163 of the Obligations and Contracts. So, of course, in a partnership, a partner, to begin the partnership, will make his promise to contribute, and all of them will contribute as a matter of fact. So the first obligation of a partner among themselves, the partners among themselves, is as to the thing promised to be contributed to the partnership. So obligations with respect to contribution of property is first to contribute at the beginning of the partnership or at the stipulated time the money, property, or industry which may have promised to contribute. And letter B, to answer for eviction in case the partnership is deprived of the determinate property contributed. So this happens when a partner contributes a real property, and so the partnership build an office, let's say an office, a shop, a plant in the property, and then suddenly another person shows up and files a case of eviction, so or ejectment, no? To eject the partnership. So there's an issue on ownership. So if ever the partnership is deprived or ejected from the property which is contributed to the partner, then that partner will answer for the eviction. So he will have to make another contribution, or he will have to pay the partnership damages. He will answer for damages. Letter C, to answer of the partnership for the fruits of the property, the contribution of which he delayed. So again, fruits of property, these are civil fruits, natural fruits, industrial fruits. So if ever the property to be contributed by a partner will bear fruits, so the fruits should be given to the partnership, because in this case the partner has committed a delay. You know? It says here with which he delayed. So the fruits to be the fruits will actually be the ownership of the partnership. So ang tag-iya na sa fruits is the partnership. So from the date that they should have been contributed up to the time of actual delivery. So letter D, to preserve said property with the diligence of a good father of family pending delivery to the partnership. So this is the duty of a person who promised to deliver a determinate object. No? If you remember in Law 211 or 231. So since the partner has promised to deliver a determinate property and is still pending delivery, so he must preserve the property with the diligence of a good father or ordinary diligence. And number 5, or letter E, to indemnify partnership for any damage caused to it by the retention of the same or by the delay of its contribution. So this answers letter C. So if ever there is delay or if ever there is ejectment, then he will have to indemnify the partnership for damages. Indemnify is meaning pay. So if ever the partner fails to contribute the property promised, then the partners become, or the partnership or the other partners will become debtor. The partner who failed to deliver the property will become a debtor to the partnership. So even if there is no demand coming from the partnership, it is automatic, meaning ex jure, no? Ex jure is automatically becomes a debtor. It's Article 1169. Now, number 2, so the remedy of the other partner is not recession. So recession is like cancellation. But the other partners will have to demand for specific performance. That is, the delivery of the object you have to deliver with damages from defaulting partner. So the partner will have to pay, deliver the object plus payment of damages. So what are the obligations of a partner with respect to contribution of money and money converted to personal use? What, no? So the obligation firstly is to contribute on the date fixed the amount he has undertaken to contribute to the partnership. So say mong isaad, on that day that you'll deliver, you have to make it good. No? Number 2, to reimburse any amount he may have taken from the partnership coffers and converted to his own use. So, ingawkaw ni siya. So if ever the partner has taken money from the partnership, he has to reimburse that amount. Letter C, to pay for the agreed or legal interest if he fails to pay his contribution on time, or in case he takes any amount from the common fund and converts it to his own use. So if ever the 2 items stated in letter A and B will happen, he will have to pay the legal interest. The legal interest now is 12% per annum or 1% per month. So he will have to pay that. So interest is a kind of fruit, which is civil fruit. Letter D, the partner will have to indemnify the partnership for damages caused to it by delay in the contribution or conversion of any sum of his personal benefits. Okay. So, what is the kind of relationship of a partnership of the partners in a partnership? So actually, a partnership is created based on trust. So, based on trust to one another, you trust the other person as your partner, and the same token, that partner also trusted you. So partnership is built on trust, and trust is what you call fiduciary duty. If you trust a person, that person has a fiduciary duty to you. So partnership is a fiduciary relation, one entered into and to be maintained on the basis of trust and confidence. With that, a partner must observe the utmost good faith, fairness, and integrity in his dealings with the others. Meaning, he cannot directly or indirectly use partnership assets for his own benefit Alright? So, bawal, no? Use partnership assets for own benefit. Letter B, he cannot carry on a business of the partnership for his private advantage. So it should not be for his private advantage, but for all the partners, including him. Letter C, he cannot, in conducting the business of the partnership, take any profit clandestinely. So what is clandestinely? This is synonymous to secretly, no? Secret or furtively. Letter D, he cannot obtain for himself that he should have obtained for the partnership. So this is a taking of business opportunity from the partnership to his personal. Because you are, if a partner is the manager of the partnership, he knows the business, no? And let's say, for example, the partnership has a client and is going to purchase the product of the partnership. So to get better profit, so siya na lang mahimo sa product for his own. He will solo the partnership. So he will not. He will solo the profit and not share the profit with his fellow partners. So this is taking a business opportunity, letter D. Let's go to letter E. He cannot carry on another business in competition with a partnership. So, a capitalist partner can, a capitalist partner is one who contributes capital. So he has many money. So, and he is not managing the partnership, no? So he can make another business. So there is a prohibition that he can make another business, but not competing or not in the same line with the partnership, no? So this is letter E. Dili pwede compete with a partnership. Letter F. A partner cannot avail himself of knowledge or information which may be properly regarded as the property of the partnership. So any secret information or knowledge or partnership secret, it should remain with the partnership, no? As their property. Sometimes a partnership, you see, a partnership is very common in Japan. Most of the, especially a limited partnership. Let's say, for example, they are a chemical producing partnership or business, and they have produced a formula for treating COVID-19. So that information should remain secret with the partnership because it is regarded as a property of the partnership. So let's go to the prohibition of competing the business of the partnership. So I stated an example a while ago here, the capitalist partner. So a capitalist partner cannot engage in a business with the same kind of business with the partnership. So for his own account or for his own profit, unless there is a stipulation to the contrary. So this is a prohibition, not an absolute one. It's only relative, no? Because he still can engage in another business, provided it is not in line or the same kind of business with the partnership. Except only if there is a stipulation or agreement which is stated in the articles of partnership. So if a capitalist partner will violate this prohibition of the law, there are consequences, and they are as follows. No? Number one consequence, he may be required to bring to the common fund the profits he derived from the other business. So whatever profit he derived from the other business, then he will have to share it with the partnership. Number two, he shall personally bear the losses. Okay. This one, if, let's say, the other business that he created bear losses, has experienced losses, then that capitalist partner will have to bear the loss. Number three, he may be ousted from the partnership. So this is from the partnership. Okay. Ousted meaning expelled. No? So that's the case of capitalist partner. Now in the case of industrial partner, by the way, industrial partner is again a partner who contributes his industry or service to the firm. No? He may be a capitalist and industrial at the same time, but an industrial partner is one who gives his service. No? So what is the prohibition of an industrial partner? It says here that he cannot engage in business within the same line of business partnership unless partnership express permits him to do so. So it's not okay. It's not properly stated here within. So actually the prohibition of industrial partner is absolute prohibition, meaning he cannot engage in business whether inline or whether it's different line of business than that of the partnership. So it's total prohibition or absolute. No, of course there is an exception if the partners would allow. Now what will happen to the industrial partner if he insisted or violated this prohibition? Number one, he can be excluded from the partnership. So the same as here, ousted. So excluded is the same as ousted. Number two, the capitalist partners can avail of the benefit he obtained from the business. So the other partners will get the profit or the benefit that the industrial partner has obtained from pursuing another business. Number three, the capitalist partners have the right to file an action for damages against the industrial partner. Like IKEA for damages. The industrial partners are prohibited to engage because they're the ones that engage in another business because they're the one who is managing the partnership. And it is required of him to focus his services or his time to the partnership. If he makes another business, then he will lose focus. Diba? His attention will be divided. Then what will happen to the business of the partnership? Okay, so that's the reason why this prohibition of the law is provided. Okay, now we discussed the obligations of a partner with respect to contribution to partnership capital. So partners must contribute equal shares to the capital of the partnership unless it is agreed in the articles or unless there is stipulation to the contrary. So the general rule in the contribution of partnership capital that the partners will contribute equal money or could be property of equal value, no? Unless there is a stipulation. Letter B, partners or capitalist partners must contribute additional capital in case of imminent loss to the business. And there is no stipulation otherwise. So, walay nakabutang, dili sila mo contribute additional. So, in this case, letter B, the partnership is in the verge of losing the business. No? Pildi na sila. So that's why, in order to make or revive the partnership, then the capitalist partner must contribute additional capital. And the contribution must be in accordance with the agreement, or if not, then equal no? Contribution. So if a partner would refuse to contribute additional capital, it is also provided here. Refusal to do so shall create an obligation on his part to sell his interest to other partners. So if he refused to make additional contribution, then the other partners, or that partner who refuses to contribute, will be obliged to sell his interest or his share to the other partners. So there are requisites here. Letter A, there must be an imminent loss on the business of the partnership. Letter B, majority of the capitalist partners are of the opinion that an additional contribution to the common fund would save the business. And then letter C, the capitalist partner refuses deliberately to contribute. Then letter D, there is no agreement to the contrary. So wala agreement nga di sila mag-contribute. No? Or he is exempted from making any additional contribution. Okay. So you have to remember here that the capitalist who fails to make additional contribution, in the case that the partnership is in the verge of imminent loss, losing the business, then that capitalist partner will be compelled to sell his interest to the other partners. That's in Article 1790. If you have a book, you can refer it and read Article 1790. The next obligation of a partner when he is managing the partnership and he collects money from a debtor who also owed the partnership. This time around, the managing partner is also a debtor to that person, and that person also owes the partnership. So this time, the person owes the partnership and the managing partner. Duha yang utang, tangan siya sa partnership, tangan pag siya sa managing partner. Now, if the managing partner will collect, then according to the rule here, the money will be applied to 2 credits in proportion to their amount. No? So, kung ano sa amount will happen? It will happen when the managing partner will issue a receipt on his name, in his name. So, letter A will apply. Then, if he received it for the account of partnership, meaning he received the money and issued a receipt in the name of the partnership, so the whole amount or the whole sum shall be applied to the partnership credit. So all of the money he collected will go to the partnership and none to him. So the requisites here, there exist at least 2 debts, one where the collecting partner is also a creditor, and the other where the partnership is the creditor. So both debts are already demandable, and the partner who collects is authorized to manage and actually manages the partner. Okay, so just remember that whenever the partner collects and issues a receipt in his own name, so letter A will apply. If he issues a receipt in the name of a partnership, then letter B will apply. Let's go to an obligation of a partner who receives share of partnership credit. So a partner is obliged to bring to the partnership capital he has received, even though he may have given receipt for his share only. So requisites, a partner has received in whole or in part his share of partnership credit. the other partners have not collected their shares, the partnership debtor has become insolvent. So in this case, the person who owes the partnership is already insolvent. Let's say there are 3 partners, and this person owes the partnership 1.2 million pesos. No, so the person is paying the partnership through the partner, and the partner received the payment, which is only good for 400,000 pesos. So 400,000 pesos is 1/3 of 1.2 million. So ningon siya, ako wala ning share. This is now my share. So the other partners, you have to wait, no? Because this person is still insolvent. So can he do that? The answer is no, no. He must share the 400,000 pesos to his fellow partners. So divided by 3, no? So he cannot say that this is my only part, this part of the payment will be my share, and the other partners will have to wait for the time we collect this person from this person. Now remember, when a person is declared insolvent by the court, he is given 3 years to recover. So meaning the creditors cannot collect from him for 3 years, for a period of 3 years. So remember that you cannot declare yourself insolvent, only a proper court of law. So insolvent is a person who cannot pay his debt or utang whenever they fall due.